On January 11, 2026, in the 36th District Court in Detroit, Michigan, Judge Shelia Johnson presided over case number 16M00402SD, State of Michigan versus Derek Farmer. The defendant, appearing via Zoom with his attorney, sought to set aside a 2016 conviction for operating while intoxicated with a high bodily alcohol content of 0.17 or greater, a serious drunk driving offense that had remained on his record for nearly a decade. What made this hearing remarkable was not the legal procedure itself, but the extraordinary transformation Mr. Farmer had undergone since his conviction, turning a moment of failure into a foundation for service to others.
Case number 16M00402SD,
sorry.
State of Michigan versus Derek Farmer Price.
Good afternoon, Your Honor. Hassan Zarar, P83043, on behalf of Mr. Derek Farmer Price, who appears via Zoom.
I think it's still morning.
Oh, I'm so sorry. I was 9 minutes off.
Yep, you are. 40 rows on behalf of the people. All right, and so Mr. Farmer Price, where are you? Tell us your name.
Good morning, Your Honor. Derek.
Farmer now.
Yeah, it's just Farmer, Your Honor.
Okay, Mr. Farmer. Well, our file says Farmer Price, so all of our orders are going to have that name on it. So
No problem.
okay. All right, so you're here to set aside a conviction. This is for operating with a high bodily alcohol content of 0.17 or more of 2016.
Yes,
Yes,
Your Honor.
Your Honor.
The defendant appeared in court seeking an expungement, legally called a set-aside of conviction, under Michigan's clean slate laws, which allow certain criminal records to be sealed from public view after rehabilitation. Under Section 780.621 of the Michigan Compiled Laws, commonly known as the Clean Slate legislation expanded in 2021, individuals may petition to set aside a first offense operating while intoxicated OWI conviction after a mandatory waiting period. The statute requires the court to find that granting the application would be consistent with the public welfare, considering whether the applicant completed rehabilitative programming and demonstrated post-conviction good conduct. In the 2022 case of People v. Gahan, the Michigan Court of Appeals emphasized that trial courts retain broad discretion in these determinations, but must evaluate the totality of circumstances, including employment history, educational achievements, and community service. Mr. Farmer's 2016 conviction for high-back OWIA, a misdemeanor punishable by up to 180 days in jail, made him eligible for this relief as a first-time offender with no subsequent convictions. Judge Johnson must determine whether his decade of sobriety, continued therapy, and career advancement demonstrate that sealing this record serves public welfare rather than merely individual convenience. Expungement laws recognize that permanent criminal records create barriers to employment, housing, and education that can perpetuate cycles of poverty and recidivism. By evaluating genuine rehabilitation rather than imposing lifetime punishment, courts can reinforce pro-social behavior while maintaining public safety through careful, evidence-based discretion.
Let me see what I got in my file. I'm looking at a criminal history record from the State of Michigan Department of State Police, for sure, from October 2016. All right. And then you've got nothing else. That was pretty
That is
fast.
correct.
Nothing other than this. All right. So my file also has a letter from the Attorney General's office dated December 8th, 2025. It's from Michael Ajami, the Assistant Attorney General from the Assistant with Conviction and Expungement Division, who basically indicates that he's reviewed the information, the application, criminal history, says that the defendant may be eligible for set aside as a first violation of the operating while intoxicated offense. And the court should look at whether or not he's benefited from any rehabilitative or educational programs if they were ordered, or whether he took steps before sentencing. And I'm not constrained by the record, and I could deny this petition if I'm not convinced that he used the programming or benefited from it after completion. And then after I hold a hearing, if I agree that the defendant meets the eligibility requirements of the statute, and his post-conviction circumstances and behavior warrant setting aside the conviction are within the public welfare, then I could grant this application. So let's talk about that first part. We'll ask counsel first, and we'll ask you to weigh in too, Mr. Farmer. The first part basically is, did you do any rehabilitative? Was anything ordered by the court? And if not, did you do anything yourself before sentencing? And if so, how did you benefit from anything that was ordered by the court?
Is
Mr.
that
Farmer?
for me or the attorney, Your Honor?
It's for you and the lawyer.
Go
So
ahead,
whoever
Mr. Farmer.
wants to go first.
Okay, Your Honor. So I was ordered to do treatment as part of the probation. However, I still continue to. I have a counselor now, a therapist now, but I still continue that. Treatment did allow me to deal with some things. I don't know if you remember, but I was when I met you, I was freshly medically discharged from the military, so I was kind of going through some things.
Yeah. PTSD, maybe.
Definitely diagnosed with PTSD. So now I have the tools that's necessary to maintain my lifestyle. So that's not a hinder for me anymore.
Good.
The defendant testified that court-ordered treatment helped him address underlying PTSD from military service, and he voluntarily continued therapeutic services nearly a decade after his sentence concluded. Under Michigan Court Rule 620 Secal 20 Swens, courts ordering probation for OWI offenses must require substance abuse assessment and treatment when indicated. More significantly, Section 780.621 2b explicitly directs judges to evaluate whether the applicant participated in rehabilitative or educational programs and whether they benefited from such programming. The legislative intent, articulated in People v. Maxson 2020, treats rehabilitation as a dynamic process rather than a box to check. Ongoing engagement with mental health services demonstrates sustained commitment to recovery that statutory drafters intended to reward. Mr. Farmer's testimony directly addresses the statutory factors. He completed mandated treatment, experienced measurable benefit in managing service-connected PTSD, and proactively maintained therapeutic relationships. His military discharge context explains the offense nexus self-medication through alcohol, while his continued care demonstrates that rehabilitation extended beyond compliance into genuine personal transformation. Veterans with PTSD face substantially elevated risks of substance use disorders and criminal justice involvement. By recognizing treatment engagement as evidence of rehabilitation rather than mere sentence completion, courts validate recovery pathways that address root causes rather than symptoms, potentially reducing recidivism and supporting veteran reintegration.
Your Honor, if I may as well, this is Mr. Farmer's only conviction, as you stated. He is fully statutorily eligible. He is a prime candidate for such relief, in my opinion. He is employed as a supervisor of probation. He works at the 36th District Court. He has 2 children that he takes care of. This is a stain on his record that does not reflect the person that he is now 10 years later. He has nothing currently pending in any jurisdiction. And I sincerely do believe that his post-conviction circumstances and behavior warrant setting this aside. And we hope that the court uses their discretion in doing so.
All right. Did you go to AA meetings too, Mr. Farmer?
Yes, Your Honor, I did.
That was
AA,
ordered.
I did the weekend class at the hotel as well as outpatient treatment.
Yeah, the class at the hotel, was that the Impact weekend?
Yes, Your Honor.
How did that affect you? What did you learn from the Impact weekend?
Actually, that weekend, I actually met gained some great resources. I had learned that my situation was not unique, and that, I wasn't the only one that experienced that, and especially not coming out the military, even though it felt like it. So just being able to talk to people who knew what I was going through and not feel so judged was beneficial for me, Your Honor, in my treatment.
All right. And of course, talking about your post-conviction circumstances, we haven't picked anything else up, which is great. Anything you wanted to add as far as community things you've done or anything like that?
I still volunteer with the same programs as well as through my church Victory Fellowship mentorship program. Um, I would like to say that since this, I have completed 3 degrees since then. I went on to get my master's, and I'm working on my second master's as right now in counseling. So
Oh,
I definitely
wow.
took this as a learning experience. I often tell people like it's the best thing and the worst thing that ever happened to me in my life at the same time.
Yes, I often say that to people. I literally say it that sometimes what looks like the worst thing in the world can actually, in a weird way, be a blessing that just turns into something really good for you. So I'm glad to hear that. You're going to working on a second master's in counseling. What are you going to do with that, you think?
I think eventually when I'm done working in corrections, I would like to start my own counseling program for at-risk
It's
youth.
wonderful. I love it. I think this is great. All right. Well, we've heard from you, your lawyer, and we've heard from the attorney general. Let's.
With no objection from the prosecutor and attorney general approval, the court proceeded to make detailed factual findings required by statute before granting the expungement application. Section 780.6213 mandates that courts issue written findings of fact addressing specific eligibility criteria, no more than 3 felonies, no assault of crime expungements, no pending charges, completion of waiting periods, and no prior application for this conviction. The statute further requires evaluation of post-conviction circumstances and behavior under Section 780.621. 2c, incorporating employment stability, family responsibilities, and community engagement as relevant factors. In People v. Catanzarite, 2019, the Michigan Court of Appeals held that trial courts must articulate sufficient reasoning to permit meaningful appellate review, rejecting perfunctory approvals that fail to demonstrate statutory compliance. Judge Johnson methodically recited each statutory element, verifying Mr. Farmer's single conviction, clean decade-long record, and first-time application before extensively documenting his rehabilitation through employment as a probation supervisor, educational attainment including multiple degrees, and volunteer mentorship. This detailed record protects against appellate reversal while honoring the legislative framework's emphasis on evidence-based redemption. Structured judicial findings prevent arbitrary expungement decisions and ensure consistent application of redemption-focused policies. When courts explicitly connect rehabilitation evidence to statutory language, they create precedential value for similarly situated applicants and reinforce that expungement represents earned relief rather than automatic entitlement. Judge Johnson, so the court is going to make the following factual findings with respect to your application. Once I find my order, I did read into the record the Michigan State Police report, so I'm finding that you have not been convicted of more than 3 felonies. In fact, have not been convicted of any felonies, just 1 conviction, and that's it. So I find that you also have had no convictions for assault of crime set aside. Currently, there are no charges pending against you, and that you have not been convicted of anything within the applicable statutory time frame, that this is not a felony punishable by more than 10 years of imprisonment. This is a first offense operating while intoxicated offense that you're requesting to be set aside, and that you have not previously applied to have this first violation of operating while intoxicated type conviction set aside. Required under the statute for this conviction has passed, and that an opportunity was given to the Attorney General and the prosecuting official to contest the application. Neither has done so. Judge Johnson, the Attorney General just directed the court to make a finding as to whether or not you had rehabilitative services that you participated in, or that you set something up on your own if it wasn't ordered, and how did you benefit from it, and you did do treatment that was ordered. And amazingly, this is a 2016 case and you've indicated you still continue treatment. You've indicated that the treatment has been very helpful and allowed you to deal with many things that you were suffering from, which may have likely caused you to drink in excess. Things from the military, including PTSD, and now you've got all the tools that you need so that you don't have to worry about relapsing into whatever was going on back at the time. So that's wonderful. You did attend the Impact Weekend and AA meetings as well. And you said they gave you the resources that you needed, and you heard things that kind of encouraged you to feel like you weren't the only one out there alone suffering and have been involved in this kind of offense for similar reasons. So it was helpful for you to maintain your sobriety to understand you're not alone and you're not the only one that went through this. Judge Johnson, as far as post-conviction circumstances and behavior, you got a great job as a supervisor in probation at 36th District. You have 2 children. Looks like you've done a 180-degree turn, gotten everything together. This is the only thing on your record. You still do volunteer work at the same places, including your church mentorship program for kids. And even more impressive is the fact that you finished school and got to one master's. I don't know how many masters, at least one, probably two, and now you're working on a second degree. So this is just amazing, and I think that you're a poster child for what you can do when you put your mind to it, and you want to heal from within, and you've done that. So it's my honor and a privilege, Mr. Farmer, to be able to sign my name on your application, granting the application to set aside this conviction for operating with a high bodily alcohol content of 0.17 or more. Judge Johnson, usually we try to keep a little tact and decorum here, but sir, you've done a wonderful job here. We're going to ask everybody here, and we don't have the 2 or 3 people left, but we're going to ask them to give you a round of applause. You got a standing ovation, too. Mr. Farmer, thank you, Your Honor. Congratulations. Good luck on your second degree. I know you're going to do well with that. Looking forward to the counseling for kids. Judge Johnson, thank you, Your Honor. Thank you, Your Honor. Thank you, Your Honor. Send this out. The order obviously out to your lawyer. But if you know what to do, if you need a copy, you can always get one from our clerk's office here. Mr. Farmer, okay. Thank you. Have a good day. Judge Johnson, you too. Have a blessed rest of your week, Your Honor. Mr. Farmer, thank you very much. You too. Thank you. This hearing illustrates a fundamental tension in criminal law. Punishment versus redemption. Michigan's expungement framework, substantially expanded through 2020's Clean Slate reforms and subsequent amendments, reflects a growing legislative recognition that perpetual punishment undermines public safety more than it protects it. The statutory architecture, mandatory waiting periods, prosecutorial notice requirements, and discretionary judicial evaluation attempts to balance community protection against the economic and social costs of permanent criminalization. The case also demonstrates how rehabilitative programming, when properly designed and engaged, can interrupt cycles of trauma and substance use. Mr. Farmer's military service created vulnerability that the criminal justice system initially punished. A decade later, that same system acknowledged its capacity to recognize transformation. His trajectory from defendant to probation supervisor, from untreated PTSD to counseling student, embodies the policy rationale that employment and educational opportunity, unblocked by criminal records, generate positive externalities far exceeding individual benefit. For legal educators and practitioners, this transcript offers a model of judicial engagement. Judge Johnson's detailed findings, her explicit statutory grounding, and her human recognition of the applicant's journey. The standing ovation, while unconventional, signaled something courts rarely express, that the law can be an instrument of grace when wielded with wisdom. If you or someone you know has a Michigan criminal record, investigate eligibility under the Clean Slate laws. Many offenses now qualify for automatic expungement or judicial set-aside that were previously permanent barriers. Consult the Michigan State Police expungement checklist or a licensed attorney to determine whether rehabilitation can be formally recognized. For veterans specifically, veterans treatment courts across Michigan offer specialized dockets that address service-connected conditions underlying criminal conduct, potentially preventing convictions that require later expungement. The law increasingly recognizes that redemption, properly demonstrated, deserves legal effect.